Hello, everyone. Ed Cross, the restoration lawyer here. I hope the year is off to a great start for you and that your family is staying safe and healthy during these challenging times. I want to talk to you today for a few minutes about a case called the State of California versus Montgomery Sandstone. I've received a number of questions in my office this week about this case, particularly with respect to assignments of benefits. And there's a little bit of confusion going on out there, and I'm going to try to dispel some of that right now. The first thing that we need to keep in mind is that the ruling of the court in this case is not California law. This is a ruling by a trial court. Trial court rulings apply to the facts of that one case and the parties in that case. Trial court rulings are not binding on other courts or other parties. In this case, California law was not changed regarding assignments of benefits or anything else. What was the case really about? The case was about illegal public adjusting and the failure to use contracts that comply with California's strict rules about home improvement contracts. And you may have heard me mention before that under the California Business and Professions Code, there are very strict rules about what you have to include in a residential contract in the state of California. In fact, there's about 36 different sections that you need to include in a California contract that come straight out of the code, and that's for residential contracts. And if you don't use those, then your contract can be considered illegal. And that's one of the things that the contractor in this case got in trouble for. The other thing the contractor got in trouble for was advertising that he would provide insurance negotiating services. The court found that he was engaged in illegal public adjusting. What is public adjusting? Let's get clear on this once and for all, because this is something else that causes a lot of confusion for people. Public adjusting is when you are representing someone else on their insurance claim. You are acting as their negotiator, their agent, their representative. You need to either have a law license to do that, or you need to have a public adjuster's license. Well, the defendants in the Montgomery Sandstone case did not have a public adjuster's license, but they were holding themselves out as being able to offer insurance claim negotiating services. And that's illegal. That's illegal public adjusting in the state of California. What sorts of things were they adjusting? Well, it wasn't just property damage. They were getting involved in negotiating things such as additional living expenses. They were accused of being involved in the preparation of proofs of loss. None of my clients ever engage in any conduct like this. This is unusual. I hadn't heard of a case like this, and it's really kind of extraordinary, and it's not a surprise that they got in trouble for this. Now, the contracts that they were getting signed did not comply with the California residential rules in terms of stating a price, in terms of stating the scope or the completion date, or the many of the other requirements that we have here. So they got in trouble for public adjusting. They got in trouble for illegal contracting. And as part of their punishment for all of this, the court said that this party was going to be restrained or forbidden from, number one, further false advertising, number two, public adjusting, number three, from getting AOBs, assignments of benefits. They were depriving this one particular individual of the right and the privilege to use an assignment of benefits as part of the punishment. The court in the state of California versus Montgomery Sandstone did not rule that assignments of benefits are unenforceable. The court didn't even talk about the enforceability of assignments of benefits. That's not what the case is about. So, trial court rulings are not binding law. Montgomery Sansome is not the law of the state of California, but there are some important takeaways that we can get from this. Number one, don't offer to be the negotiator for a policyholder on their insurance claim, particularly with things like additional living expenses and preparing proofs of loss. Stay in your lane. That's not your lane. Don't do that. Keep your advertising truthful. Don't advertise that you can provide a service which you cannot provide legally, for example, if you don't have a license to provide it. Use contracts that comply with California's home improvement law, and don't write fake estimates. The court was very concerned that the defendant in this particular case had written estimates that weren't real. They had fake numbers in them. As a matter of fact, the defendant testified that the numbers were just placeholders, and they would kind of figure out later on what the price was going to be. So keep it honest, keep it real. And here's a tip from me. I believe that using a properly drafted assignment of insurance rights actually will protect you from being accused of public adjusting, because you become the owner of that portion of the claim, and it's narrow, it's just for your scope of work, and then you cannot be negotiating on behalf of the policyholder, because that policyholder has transferred that right to you. You own it. You are negotiating on your own behalf. So when you're talking to an insurance company about a price, for example, don't say, I represent the homeowner. You don't represent the homeowner. You've heard me say this many times before. You represent yourself. You're speaking on behalf of the restoration company. If you would like to have a free preview of what a good assignment of benefits looks like, or a free preview of a compliant California home improvement contract, shoot me an email at ed@edcross.com and write preview of assignment or preview of contract in the subject line, and we'll send that over to you. So thank you very much, and stay positive and test negative.